The protective order deception. We all know that a protective order provides little to no substantive protection for the purported victim. What do I mean? Well, the joke around the legal profession is that when a bullet, blade, bat, or fist is headed your way, just hold up the sheet of paper on which the protective order is printed to stop it. You see the point. We also know that while many real victims of abuse seek protective orders for legitimate purposes, many protective orders are often sought, in my opinion, most protective orders are sought, in bad faith by people to gain an ill-gotten, unfair advantage over another through a bogus protective order application. So if someone is truly afraid for his or her life or safety, why not have the would-be protective order applicant get a gun instead? Some real protection. Not invincibility, not even 24/7 protection, I admit that, but far, far better than mere sheet of paper protection. Besides, anyone who's truly fearing for his or her life or safety isn't going to find any protection in a court order. As they say, when seconds count, the police are just minutes away. Indeed, if the stories that protective order applicants told were always true, meaning if it was true that every protective order applicant has already been abused or abuse against them is or was being attempted or threatened, then shouldn't the number of people stopped by a mere sheet of paper be remarkably low? In other words, why doesn't the alleged abuser just keep trying to abuse in spite of a mere sheet of paper telling him or her not to abuse? To suggest it's the protective order doing that instead of somebody not actually being guilty of committing abuse. Do you see the point I'm making? It's not as though a perpetrator reads the protective order after being served with it and says, well, as long as this piece of paper tells me I can't kill or injure, then I have no choice but to respect the court order. That's not what happens. Murderers and determined abusers won't be stopped by pieces of paper any more than they are stopped by laws already on the books that prohibit murder and abuse. Indeed, something can be said for the idea that falsely accusing someone of being an abuser and then ejecting him from his home and subjecting him to public ridicule and scorn and being cut off from his kids or her kids, as the case may be one of the best ways to foster abuse in situations where, but for the issuance of the ill-gotten protective order and all the underlying allegations, no abuse would ever have occurred in the first place. Being falsely accused and falsely slapped with a protective order is humiliating and destroys an innocent's faith in the legal system. Falsely obtained protective orders create a sense of betrayal and anxiety that causes many an innocent person to reason that if innocence isn't a protection against false allegations that kill reputations and careers and separate loving parents from children, then I might as well become what I've been accused of being. As Johann Wolfgang von Goethe said, the way you see people is the way you treat them, and the way you treat them is what they become. I had a client who claims that a bogus protective order was entered against him. I have no reason to doubt what he said was true. There was no verifiable evidence that any of his wife's, or ex-wife's in this case, self-serving allegations made in advance of her filing for divorce, of course, were true. There was no history of violence or abuse in his past. The only thing the wife could use against him when she made her original request for the protective order, and I'm not kidding, is that he had received combat training when in the due course of his military service 20 years before she applied for the protective order. The protective order had been in place for 12 years when his daughter, who at that point was now an adult, was engaged to be married. He wanted to attend the wedding and the wedding reception. Utah law required at the time that he make a request that the protective order be dismissed because it was a permanent protective order. When he made that motion to dismiss, his ex-wife, remember, this is 12 years gone, she opposed the motions, claiming that she was still afraid of him, even though in her affidavit, she stated that she had no contact or communication with him in those 12 intervening years. In other words, he had obeyed the protective order without exception and without complaint. No contact in 12 years, no incidents of violence or attempted violence or even threats of violence in 12 years. But all it took was her claim that she was, quote, still afraid. No evidence he had in fact committed, attempted to commit, or threatened to commit any abuse. No evidence he was in fact a threat to her in any way. Indeed, all evidence was to the contrary. She said she was still scared, but couldn't explain why. But that's all the judge needed was her claim. The protective order stayed in place, not even amended, to make it possible for him to attend the ceremony or the wedding reception, and this man missed his daughter's wedding. That's real abuse.